Session 6, the Board of Directors. What we're going to do today is talk about the key issue in corporate governance, the role of the Board of the Directors, and we go through some of the fundamental things. How does one become a member of the board, and how does one get kicked out of the board, and what is it that they need to do? So like a fundamental idea of what is the idea of corporate governance, what's behind it, what are these people managing, how do you get them in, how do you get them out? The idea of corporate governance is about effective running of corporations. And the idea of an effective running of a corporation is not only of interest to company insiders, it is of interest to everybody else as well. Crucially, effective corporate governance is that a company is run in a way that serves the objectives of different within the company and manages to find some appropriate balance. And you, definition, have people with different interests. You might have, especially in a public limited, short-term people who are interested in the value of the share on a day-to-day basis because they buy the shares now, sell them tomorrow. You've got longer-term shares that want the company to be successful in one because they intend to keep the shares and they make the profit dividends. For some people, the transactional value of the share is more important. For other people, it is the ability to make money out of different things. So you've got this in the body of the shareholders themselves. And then you've got everybody else who's involved in the company, the people who run it and manage it, and the various people who are employed in it in various capacities are interested in the health of the company in the long run. But maintaining profitability, maintaining balance of interest in the short term and the long term is tricky. Effective corporate governance is about doing all this correctly. But as I said, it is not only something that is inward looking, because a corporation that fails is trouble not only for its shareholders, whose interest and wealth are out, not only for the employees that might find themselves without of a job, but it can have negative consequences on the rest of society. And that demonstrates that the consequence of a company doing badly is not only internal. Thomas Cook, their customers are severely affected by this, stranded all over the place. Also trouble for the authorities trying to organize these people coming back in some way. You could argue that some of these businesses are closing down because of general economic conditions. So no matter what the management has done, if the economy is going through a crisis and people are not spending, so if you're running a pizza place and people don't have the additional income to go out on Saturday night and have a pizza with their family, obviously you're not going to do well and there's nothing you can do about it. What concerns us is failure that stems from bad decision making, is from companies failing to appropriately organize themselves internally, finding correct competing interests and making the wrong decisions. So companies that prioritize day-to-day profitability might make decisions that are bad for the long term. They invest in products or they keep products running that don't have a future. The other way around, companies that are too forward-looking and take a big bet on something that they think is going to be profitable in the future, they might incur too many loans that they cannot service. They might take too big risks in big investments that might freak everybody out and they fail in the process. Also, what is important in terms of corporate governance is the balance between the shareholders having some say in decision making and the board of directors doing their job. And the board of directors is the body that is tasked with managing the day-to-day. The approach of the law here is to let the companies do things on their own and make appropriate decisions for themselves. So English law is not particularly prescriptive. What you have, if you're looking, for instance, at public corporations that are listed in the stock market, you have the Corporate Governance Code, which is an attempt by the authorities. So this is an arm's length body. The London Stock Exchange is not the government itself, but it's a recognized body, it's a recognized institution, and it comes up with a set of rules that are expressed in the corporate governance code, that is best practice recommendations as to how to organize yourselves in the best possible way. But these are just recommendations, you see. The government has not taken the view that the law should tell companies how to do stuff and when to do them. The law should not mandate who participates in management, who participates in these decisions. This is up to within the general framework of the Companies Act, but it is within the power of the companies themselves to decide how people are present in these decision-making structures. And what you see, what our 20 credit students are doing, for instance, they're writing their essay on the balance of the board. I think between should you have a multi-tier board with different groups represented, mandated by law, or should you let this to the company to decide themselves? The approach in English law is to let the companies run it themselves, decide what works best for them. A consequence in the corporate governance code is to have a system that is called comply or explain, which means you are invited to follow the recommendations as to what is best practice in running your company. And if you choose not to do it, you're not going to be fined. They're not going to shut you down. Your prosecutor is not going to come after you. But you then have an obligation to report back to your own shareholders and explain to them why you're not following best practice recommendations. So you need to engage with your own shareholders if you're the management and tell them, we are not complying with the code because this is not appropriate for the business we're running for XYZ reasons. Other countries have taken a more prescriptive approach that says, no, everybody's obligated to do the same things in the same way because we think that is the best way to do it and it makes it safer for everybody. Every company needs to be headed by an effective board, and this board is responsible collectively, so all the directors, they're responsible together for the long-term success of the company. And what the law mandates is that the board of directors are to provide leadership to the company and a framework of checks and controls which enables various business and legal risks and all the rest of it to be adequately managed. So the board is there to set the company's strategic aims and direction and to ensure that the necessary financial and resources are available for the company to be able to reach those objectives. Part of their job is to review on a regular basis progress towards those objectives. The board is the one that sets the company's values and standards and ensures that obligations to shareholders, internal stakeholders and external stakeholders are met. So the job of the board of the directors is to be the captain of this ship, right? They determine the direction of travel, they determine the means to achieve that, to reach that direction, and they have the job of checking on a daily basis that things are progressing appropriately, to have the mechanisms of control in place to check out that all this is going, and some capacity to react when unexpected things happen. All of this is the mandate of the board of the directors. It is not the responsibility of individual shareholders. A shareholder is somebody who wants to participate in that project, but will only be consulted, as we've seen already, for major strategic decisions, the nature of the framework that governs the company through changes in the Articles of Association. The shareholders will not do the day-to-day management. Now, in reality, a company that is adequately responsive will make sure that the strategic direction set by the board are actually shared by the shareholders. Because if you're a private limited company, the number of shareholders is fixed, is normally not very large. The shareholders are probably represented themselves in the board, they're the same people, so it makes sense that there's a commonality of interest. In bigger companies, in companies perhaps listed in the stock, you will still have, as I said at the beginning, some shareholders that are there for the long run. So it makes sense to ask them what they want to do and what their view of the company is going forward in the future. The shareholders are not obligated to participate, but a responsiveness and management understanding their needs and objectives can only be good for the health of the company. Where do the powers of the board come from? This is securely set in the law, and it's been the content of a lot of cases as well, because this is what people are arguing about. You will find that the default position in the model articles of association is that the board is responsible for the daily running. So you will see in Article 2 or in Article 4 and so on that you do have this expressly mentioned in the Articles of Association. Whether you've got expression of this or delegations of authority and the degree to which you can delegate authority will also be present within the Articles of Association. What has come as a bit of a problem is exactly the idea that the board might choose to subcontract its own powers to somebody else. So you come across cases, Shaw and Sons and Shaw from 1935, where the court was asked specifically to address of who is running the show and what is the balance of power between the board and the shareholders, and they came up with the idea that the powers of management, when they're vested in the directors by the Articles of Association, this is the end of it. It is the constitutional document of the company that puts the directors in charge, and the shareholders, even in their majority, cannot decide to take away these powers from the board and exercise them themselves. This issue appearing in the courts again and again when you've got conflict between what the majority of the shareholders want to do and what the board of directors are doing. So you got other cases that discuss the same issue. You've got automatic self-cleansing there. You've got Quinn and Axton's that discusses the degree to which the general meeting can interfere in decisions of the directors. You have final resolution of this issue in Shaw and Shaw and in Scott versus Scott from 1943. This was not obvious at the beginning. And as you will see, these cases are fairly old. So these are the kind of this fundamental debate is taking place at the beginning of the 20th century. At that point, the statutory provision was not secure enough in the division of responsibility between the board of directors and the general meeting. That's why you had this case. Now, we have this nailed down both in the Companies Act and in the model articles. So if you look at the model articles, if you look at the ones for limited companies, for instance, you have Article 3 that lays down the director's general authority, and it says that the directors are responsible for the management of the company's business, for which they exercise all the powers of the company. And the shareholders have a lesser role as a reserve power that they can exercise when the board is not operational. If the board gets into a position where they cannot make decisions, they're at complete deadlock, or some of the directors have run off and they cannot have meetings and so on, then the company cannot stay without management. So at that point of board failure, the general meeting is allowed to come in and exercise its residual power. But the general meeting is not allowed, both from the case law and the statute and the Articles of Association, is not allowed to jump in and take over management when they disagree with what the board of directors is doing. What they can do is that they can remove the directors. They can change the board. That they're allowed to do, but they cannot exercise its powers themselves. You have a dynamic relationship between the two, and you've got a division of responsibility, but one cannot fully substitute for the other. The correct approach is, if you disapprove of your government or you disapprove of your management, then you replace them with another team that better expresses your desires. Present within the Articles of Association, it means that can have complex management structures, board of directors at the top, and then a series of managers who are employees that carry out the traditional management functions. While delegation is possible, however, you need to remember that the board is ultimately responsible. So the board cannot say, oh, it's not my fault anymore because I hired a professional manager with a great CV and now they're running the company and I'm going to Tenerife. If you are a director of a company, the decision-making, the responsibility comes back to you. No matter how qualified or whatever it is or how strict mandates your managers have, the ultimate responsibility stems from the board. Being a director in the board of a company is not a job. It's a function. It's an office. So you have this. If you're a director, you're not entitled to payment, for instance. You'll only get paid if, in addition to your position as a director, you're also hired as an employee to be a senior manager. So the fact that you're a director of a company is not a job. However, it comes with a set of responsibilities, which is, as we said, to be responsible for what's happening in the company, to manage the affairs of the company, and if you don't do it properly, you suffer both civil and criminal law consequences if you don't do your job properly, or if you forget stuff, or if you're negligent, or if you make mistakes, or if you forget your communications to company's house, you can get into very serious trouble. If anybody offers you to become a director of a company, don't say yes unless you know what you're getting into. They will not necessarily pay you, and you will have to do a lot of stuff that are fairly serious. The tension between the general meeting and the directors, because as we said, the general meeting is supposed to be the central decision-making body of the company and the source of its power, but then the directors are meant to be managing the show. A residual power of the general meeting comes in when the board is not functioning, but also it comes in particular issues. And we need to pay attention to this when the management needs to go back to the general meeting and ask them to do stuff. For they're the boss and they run the show and they make decisions, but some stuff they cannot do on their own. And these are down very clearly in various pieces of legislation. For instance, what are the general issues that the board of directors is obligated to go back and ask the shareholders? If you want to change the articles of association, you cannot do this on your own. You cannot do this without consulting the owners of the company. You need to go back to the general meeting. If you change the type of incorporation to go from private limited company to public limited company, if you want to issue additional shares or to suck back some of the shares that you had, if you want to make any changes as to class rights, and if you want to do some other things that have to do with mergers and acquisitions or shutting down the company and so on. These are all stuff that are not within the power of the board of directors to do on its own. You need to go back to the shareholders. And also there are some corporate governance. These come from the law. These come from the Companies Act or the Insolvency Act. These things come from the Corporate Governance Code that is relevant to public companies listed in the London Stock Exchange, appointing auditors, certain big transactions, or things that the directors might do in relation to opportunities that present themselves in the company, or dealing with an attempt at a takeover and so on, then these are issues that the Corporate Governance Code says you have to go back and consult with your shareholders. And finally, something has to do with listing in the stock market. Transactions above a certain size also need to be approved by the shareholders to make sure that the management hasn't gone crazy and buys some foreign corporation for billions and then they go bust. Link between what the board of directors is tasked with and what is within its power to do, and what the general meeting is entitled to do and how they can interact. It causes conflict all the time. You will get into situations that you're going very close to the dividing line, the authority of one and the responsibility of the other. There will always be an opportunity for conflict. That has two consequences. A, it generates a great deal of case law. That's why you got such a wealth of cases about these issues. One of the important things that we have to address is one director, right? When you're first setting up the company, you already need to name the people who are going to be directors. Usually in private limited companies that are starting relatively small, the same people who are shareholders are also going to attain some positions in the board. So if a little business together, manufacturing kind of toilet flushes or something, and there's 2 or 3 of us, it's very likely that we're going to share divide the shares between us, and also we're all going to be represented in the board of directors. So then there's a commonality of interest between the board and the shareholders. Things are obviously a little bit more complicated when you get into bigger corporations, especially in the public corporations, when you got a much wider shareholding and much more fluctuating shareholding. The directors in these companies are elected in their position. And the Articles of Association, we have the mechanism through which the general meeting elects the board of directors. It is not obligatory that they sit for re-election on an annual basis. However, it's very common that this happens in larger corporations. That's why you hear sometimes in the press about a board getting re-elected or facing some pressure. Equally, if you think about the remuneration of directors, how much they're getting. In small corporations, this is something that gets kind of debated since the shareholders and the directors are the same people and they need to find the appropriate balance between personal reward and reinvesting in the company. Payment levels for directors who are also hired as employees are okay. The problem is with bigger corporations where directors are brought in as specialist managers with specialist skills in an internationally competitive market, and in certain industries they get paid a lot of money. Now, whether they're worth that money or not is subject to negotiation or debate between us, but the reality is that people do get paid a lot of money. Especially in the banking industry, you get the senior managers who will also be part of the board. These people are paid in hundreds of millions of pounds every year. Because you've got such a problem with executive remuneration, as it's called, of those higher levels, these are things that now are coming back to the shareholders. Part of deciding how much you're going to pay people comes back to the general meeting to approve. And this comes from discussion on executive pay from the UK Corporate Governance Code that says that these things need to come back to the shareholders and an easy way for the shareholders to show dissatisfaction with the management is to vote down the pay package. Perhaps it is a little bit more difficult to kind of address issues of strategy because the general meeting doesn't get to vote on issues of strategy all the time, vote on executive pay. So if you vote down the pay package, this is a very good way to give a message to the management that you're not happy. Remuneration is something that comes back to the general meeting for these types of corporations. Section 168 is important, perhaps, that can be by the general meeting. It is the opportunity to remove directors. Ordinary resolution. What does an ordinary resolution mean? Majority. You need a special majority to change the articles of sense, but to remove the directors, if you don't like them, you just need an ordinary resolution. The general meeting doesn't to influence decision making, but what they can do is that they can convene and they can tell the board, you're out. It doesn't happen very often, it doesn't happen all the time. Power to do it is a very useful disciplining mechanism, and the way that this is actually done is not for shareholders being unhappy in the abstract. Something gets them to do it. What you have is that somebody external will come in, buy a few shares in the company, enough shares that give them the right to be represented at general meeting. And at the general meeting, they're going to come and say, hello, my name is X, and I think your board sucks because your board is doing X, Y, Z. They're paying themselves too much money. They're running the company into the ground. They care more about their trips to the Canaries than they care about you guys. And look at that. I got my team here. They're all excellent people. And you vote them out and vote us in, we're going to run the company in a much better way than they are. So the people who do this, they come under the label now activist shareholders. They're basically professional agitators. They're people who run kind of financial consultancy firms and all of that stuff, that they look at what's happening. This is for public listed corporations where you can get those shares. They look at what's happening in corporations and they pick on companies that are badly managed. And then they go in and they run exactly that trick. And what do they get out of it? Well, they get jobs for themselves because they become directors. Then they get kind of nice contracts to run the show. And if they run the company in a more effective way, the shares that they bought increase in value. So they make money both by successfully running the company and increasing the value of the share, and from the fact that, they got employment contracts for themselves being a new team. And this is happening more and more frequently these days. And it's actually a very positive thing, because it gets company boards not to be complacent, to be on their toes. They know they can be kicked out with an ordinary resolution. They know that there's a lot of people looking at their performance. And hopefully, this kind of thing incentivize boards to take better care of their companies and also to take a longer view as to the performance of the company, create value in a better way, which is, I'm guessing, a good thing for everyone. The idea of disqualification. Now, what happens if a director is proved to be a terrible person? If they're terrible managers and terrible people, maybe getting rid of them from a company is not enough because there's a public interest. Maybe you want these people prevented from taking over companies in the future. So what can happen is that you can have, with the power given by Section 6 of the Insolvency Act, the authorities have the power to disqualify somebody and not allow them to become a director again for a period of time if they have done something wrong. For instance, they've been dishonest, they've committed serious offenses, they've been fraudulent in the way that they were running the company, or they failed to comply with formalities in the running of the company. These are stuff that are bad enough, not just for the individual shareholders that will get them to be kicked out, but you do not want these people to be in charge of companies again, at least for a period of time. So one of the bad consequences of kind of being kicked out is not only that you lose your job in the company, but also that if you bring the attention of the authorities to you, you might be disqualified and you might not be able to do this for a certain period in the future.